and the judgment will be enforceable in any other state. More so, the plaintiff can take that judgment to any other country in the world. Well, most every other country, like 99% of the other nations out there. And that foreign nation will recognize a money judgment from the United States. Okay? Meaning that the plaintiff can take the judgment to Switzerland, go to the local canton court, and the canton court will honor that judgment, and they will make it enforceable in Switzerland, allowing the plaintiff now go to that Swiss bank and say, hey, give us the money from this bank account. Well, what do you think will happen by the time the plaintiff gets to the Swiss bank and goes to the Swiss bank and says, give us the money? The Swiss banker is going to say, listen, we're very sorry, but about 2 hours before you got here, wire instructions came in and money was taken out of our bank account and moved to some bank in Paraguay. What is the plaintiff going to do? Well, if there's enough money at stake, the plaintiff will say, Paraguay? I always wanted to visit Paraguay. I'm going to fly now to Paraguay. I'm going to domesticate my judgment in Paraguay, get the money out of the Paraguay bank account. They fly to Paraguay, get to the bank, same story. Money was just here, wire instructions came in, money left Paraguay, went to, a bank in South Africa, whatever. Obviously, if defendants, if debtors were allowed to play these types of games, plaintiffs would never be able to collect on the judgment. Well, at least in a lot of cases, they would not be able to. So there has to be some sort of a remedy in place to allow the plaintiff to put a stop to these types of games. And there is. And it's known as a turnover order. And a turnover order is basically the judge directing the debtor, directing our client, to turn over a specific asset to the creditor. Okay, so it's not a foreclosure sale, it's not a levy, it's not a lien. The debtor actually has to take his asset and give it to the plaintiff. Okay? So the judge can order our client to take the money out of his Swiss bank account and just give it to the plaintiff. Our client always knows where his money is at. Our client, being the signatory in the account, always has access to that money, and he will always be able to give it to the plaintiff. Brings us to another important point. Simply making assets difficult to get to, somewhat difficult, is not enough if our client is still in control of that money. If our client still owns it, if it's in his name, he has the ability to bring it back. At some point in time, the plaintiff will be able to force our client to do that. Okay? So, to summarize what we've covered so far, asset protection is about making it more difficult and more expensive for plaintiffs to get to our clients' assets. And what we are not talking about is we are not talking about simply hiding assets or simply kind of moving them further away and making them somewhat more difficult to get to. There has to be somewhat more meaningful structure that we are erecting to make this work. Let's move on to the next slide. The law of fraudulent transfers, sometimes referred to as the law of fraudulent conveyances, same thing, exists in every state in the United States and exists in pretty much every single British common law jurisdiction. There it's known as the Statute of Elizabeth, but the rule is the same. In the context of asset protection planning, if someone gets a judgment against you, what types of assets can that judgment reach? Well, the general rule is that the judgment can reach virtually any and every asset that our client owns. Well, those few exemptions that we talked about earlier, like the homestead exemption or some retirement plans. But other than those few exemptions, that really are few and far between, everything else that our client owns, the plaintiff will be able to reach with the judgment. The flip side of that coin is that if there is an asset that the client does not own, the plaintiff obviously cannot get to that asset. Okay? So if I do not own this office building, if I am sued, obviously they cannot get to this office building. So to a lot of people, it seems that asset protection should be very simple. I get sued, I own a house, take the house and transfer the ownership of the house to my brother. Plaintiff comes to me and says, hey, we have a judgment against you, we want your house. And you just simply say, well, I don't own a house, someone else owns it. If we were allowed to do that, no one would ever collect on a judgment. Defendants will simply transfer assets away at the last minute, frustrating all plaintiffs' efforts to collect against them. And fraudulent transfer laws is really the mechanism that we have to prevent debtors from being able to transfer away their assets at the last minute and to frustrate plaintiffs and creditors. So how do these laws work? We'll spend just a few minutes on them. A fraudulent transfer, first of all, you have to understand, is a term of art. It does not refer to fraud. It does not refer to fraudulent conduct. So it's a term of art. And it's a term of art that describes a specific type of a transfer. And there are two transfers, and we'll talk about them, that would be deemed fraudulent transfers. So before we get to these two types of transfers, first we need to figure out, what is a transfer? Well, sounds like a simple question. I know what a transfer is. Take my house, transfer the ownership of the house to my brother. That's a transfer. True. It's not as simple as that. It's not only the plain sort of meaning of the word transfer. Within the context of fraudulent transfer laws, transfer refers to any action that the debtor takes that makes it more difficult for the creditor to collect. Okay? Any action that the debtor takes that makes it more difficult for the creditor to collect will be a transfer for fraudulent transfer purposes. So, for example, let us say that I own my assets through a limited liability company. I get sued. I want to make it more difficult for the plaintiff to reach my assets. So what do? I take the operating agreement of this limited liability company and I make some changes to build in some asset protection clauses, make it more difficult for them to get at the assets of this LLC. Haven't transferred any assets, right? All of the assets is still sitting inside the LLC. But I've done something that makes it more difficult for my creditors to get to my assets. That is a transfer for the purposes of this test. Once we have determined that we have a transfer, how do we know if this transfer is a fraudulent transfer? Well, there are two sets of circumstances that you see on your slides where a transfer will be deemed a fraudulent transfer. The first type is a transfer with the actual intent to hinder, delay, or defraud any creditor. Okay? Actual intent, whatever that means, to hinder, delay, or defraud any creditor. So let's break this down a little bit because it does need to be broken down. What does it mean to have actual intent? It means that the debtor, when he was engaging in this asset protection planning, he must have actually intended, had the thought in his head, to make it more difficult for someone to get to his assets, to hinder, delay, or defraud, is the language. Okay? So how do we know if someone had this actual intent, the specific intent, to hinder some sort of a creditor? We cannot get inside a person's head. The debtor is not going to sign a declaration that, well, I did all of this because I intended to, make it more difficult for my creditors. So how can the creditor prove what was my intent, what was the debtor's intent behind the transfer? Well, it's done through circumstantial evidence, what is known in the world of asset protection planning as badges of fraud. And badges of fraud are basically indicia that implies the debtor's intent, looking at the surrounding circumstances. So, for example, engaging in asset protection planning after the accident took place, or after the lawsuit was, after the lawsuit was filed. That is a badge of fraud. Transferring assets to an entity that the debtor owns and controls is a badge of fraud. Transferring assets to a family member, transferring assets for less than fair market value, transferring assets at the time when the debtor is insolvent. In each state, there is a different number of kind of commonly accepted badges of fraud, usually somewhere between 10 and 15. The two most important ones and the two most damaging to a debtor is transferring assets for less than fair market value and transferring assets at a time when the debtor is insolvent. Okay, and we'll come back to those two in the context of the second test and discuss them in more detail. Okay? So what the creditor will try to do in establishing actual intent to hinder, delay, or defraud a creditor is the creditor will try to establish all of these badges of fraud. What will the debtor try to do? Creditor goes to the judge and says, Your Honor, this guy, he did this, this, and that, and look at the surrounding circumstances behind the transfer. To us, they suggest that he must have intended to make it more difficult for us to pursue his assets. Is the debtor simply going to sit on his hands and do nothing? Or is the debtor going to go